Hi, my name is Jason Mills, and I'm coming to you from Fort Worth, Texas. I'm currently on the Department of State Liaison Committee for AILA, and we've had a lot of work to do, especially in regards to public charge. Today, we're going to go over some of the new bullet points and highlights and provide some resources on what now constitutes public charge. Basically, from 1999 up until this last year, the standard for public charge has remained primarily consistent. And essentially what that meant is if you had a properly executed affidavit of support, which is the I-864, there was essentially a presumption that if there was the proper documentation and the guidelines were met as far as income, then the public charge was really a non-issue. And that included non-immigrant visas and immigrant visas. Well, that has all changed in the course of the last few months with both the Department of State and the Department of Homeland Security, and probably soon to follow the Department of Justice. There's some key dates to remember. February 24th, there is a laundry list of new forms that coincide with the new regulations for public charge. That's going to go into effect February 24th. For those filing before that date, if you get your applications in before then, you will not be subjected to the new regulations. So if you have someone that you're concerned about and you need to file, it's very important to do so before February 24th. Also, on the new definitions that we have on public benefits. Public benefits are something that they've expanded upon on their list of highly significant negative factors that can be used to charge your client as being inadmissible under the public charge grounds. And so you'll need to look at those factors and make sure that you're able to address them. If you have anything that has been on the new definition of public benefits, as long as it was not also included on the old definition of public benefits, those will not be used retroactively in the analysis. So only public benefits that are applied for or certified or in effect after February 24th will be included in the analysis. So it's important to take a look at the background of your client. And part of this promulgation, there's some brand new forms and not just amendments to forms. One of those is the I-944. That form is very comprehensive, and it goes through family history, it goes through financials, it goes through assets, it requests credit reports. There is a whole lot that practitioners are going to have to do, and it's going to become the new normal, and you need to learn it. And you may even have to charge your clients more fees. I know we don't want to do that, but this is going to involve a substantial amount of time to prepare these forms correctly so that we are able to properly represent our clients. So it's good to get familiar with that form now, put a system in place to do that, because your clients are going to have to bring in a lot of evidence that you're not used to providing. And with regards to the analysis, it's important to be aware that they're going to look at several factors, which are somewhat statutory. That is age, education, family status, financial assets, among other things. And within that, in the new regulations, there's also what they've constructed as highly positive factors in the analysis and highly negative factors. It's very important that practitioners are aware of what those factors are, because while they call them highly negative and highly positive factors that could be overcome in certain grounds, to me it sounds like more of a presumption, and that's how you need to look at that when you're approaching these. For those who frequently consular process or who are engaged with Department of State on a regular basis, we see that currently in the Foreign Affairs Manual, it's in conflict with the newly enacted regulations that DHS is going to go into effect February 24th. The reason for that is they tied a questionnaire that's similar to the I-944, but it's their own promulgated questionnaire. Once that it was released, then they were going to issue a final rule for their regulations, which would mirror those of DHS. Well, it sounds like now, as of a few days ago, DOS has requested OMB to have everything finalized and approved for the questionnaire so that it can be published, and their implementation are going to go into effect at the same time. The one difference between the two of those, though, it seems that the Department of State is still very discouraged on bonds. DHS has come into view to where they have a lot of provisions to where if somebody might be found inadmissible, but could overcome based on just discretionary factors, that that finding, they can post a bond. And so there's procedures in place for do that to DHS. DOS has frowned upon those so far. Maybe that will evolve in the future, but for the most part, both Department of State rules that have been promulgated and not quite into effect yet, but soon should be, are a mirror, almost copy of those of DHS. So if you're familiar with one, you should be familiar with the other. So these new rules are about to go into effect February 24th, except for the state of Illinois. So if you reside in the state of Illinois, you still have the rules that have been in place since 1999 and the guidance there too. Up until such time as some of the injunctions are listed or lifted or this lawsuit ends, those who are domiciled and filing, whether it's a place of employment or where they are residing, and they're filing within that circuit in the state of Illinois, this is not going to count. The public charge changes require a lot of analysis, and it's important to get all the information up front from your clients at the beginning of the case and start a strategy and a plan. Depending on their demographics and where they're coming from, everyone's going to have a different background, and you're going to need to address the issue from the very onset of the case for the maximum chance of success for your clients. In order to do that, AILA has a fantastic web page, which is a featured issue page on public charge, and it goes through everything from litigation trackers on what's going on with any injunctions and lawsuits. It has policy guidance on there. It has links to some of the CIS websites with the new forms that are going to be promulgated, and the previews are out currently to be familiar with those. So it's a great resource, and it's something that all of us now, regardless of how we practice, is going to be an issue in it, and you need to get familiar with it.